All right, if you're heading for the bar, listen up. There's a powerful weapon in your litigation arsenal that you've absolutely got to master: summary judgment. And let me tell you, the definitive masterclass on how it works comes straight from the High Court in Spencer versus Commonwealth. Getting this case is not optional.
Okay, so this one sentence, this is everything. This is the High Court drawing a line in the sand and saying, hold on a minute, overturning two lower courts in the process. This single phrase completely rebooted the entire system for stopping unwinnable cases early, and it all boils down to one critical question.
What in the world does no reasonable prospect actually mean when you're on your feet in court? To figure that out, we need to dig into where the law came from, what the High Court specifically warned judges not to do, and, most importantly, how you can use this knowledge in your own practice.
Okay, so here's our game plan. First, we're going to take a trip back in time to the old, nearly impossible, hopeless test. Then, boom, we'll see the game changer, Section 31A, hit the scene. From there, we'll dive into the High Court's masterclass on how to read the new rule, and we'll wrap it all up with what this means for you, your practical toolkit. Let's get into it.
So let's start by rewinding the clock. Imagine a world before Section 31A. Back then, if you wanted to get a case tossed out of court early, well, good luck. You were facing a massive, massive challenge. The bar was set so ridiculously high, it was almost unreachable.
And those words, hopeless and bound to fail, they weren't just, some fancy legal terms. They reflected this really deep-seated judicial philosophy that everyone deserves their day in court. So judges were incredibly hesitant to just slam the door shut on a litigant before they'd had a proper hearing.
I mean, listen to this. This wasn't about showing a case was probably going to lose. No. You had to prove it was an absolute goner from the get-go, so certain to fail that it was an abusive process just to run it. Think about that for a second. You needed 100% certainty. That is a wild standard in the world of law.
So this impossibly high standard was obviously creating some issues. So Parliament decided to step in, and they introduced Section 31A, and let's be crystal clear, this was not some minor adjustment. This was a whole new ballgame.
And as lawyers, you know the exact words are everything. So let's look at them. Subsection 2 gives us the new magic phrase, no reasonable prospect. But honestly, subsection 3 is the real haymaker. It flat out tells the courts, that old hopeless test you've been using, yeah, forget about it. It's gone.
And this is the shift, right here. You can see it plain as day. We moved from a world that demanded certainty of failure to one that simply asks about the reasonableness of success. And the High Court didn't mince words. They called this a radical departure. This wasn't an evolution, it was a revolution.
Okay, this brings us right to the heart of the matter, the Spencer Masterclass, paragraphs 49 to 60. This is basically the High Court handing down the instruction manual for this new test. And interestingly, they start by telling us what not to do. They lay out 3 huge traps you have to avoid at all costs.
Trap number 1, don't look backwards. The court, at paragraph 56, literally uses the word dangerous to describe trying to understand this new law by looking at the old cases. The message is simple and blunt. The old rules are dead. Leave them buried.
Trap number 2 is don't go borrowing tests from other countries, specifically the UK. The court makes a really big deal at paragraph 51 about this. They point out that the UK has a no real prospect test, but ours is no reasonable prospect. Now you might think, reasonable, what's the difference? Well, to the High Court, it's a world of difference. They are not the same thing. Don't get them confused.
And trap number 3, this is a big one for us as advocates. Stop making up your own words for the test. At paragraph 58, the court warns against creating a lexicon of words or phrases. You can't just substitute in words like fanciful or untenable and think you're applying the test. You're not. You have to stick to the actual words Parliament wrote.
So after telling us all the things we shouldn't do, the High Court gives us the one clear positive instruction. And this, right here, is the golden rule from Spencer. Forget the paraphrasing. Forget the shortcuts. You must give full weight to the expression as a whole. That means you have to engage with the entire statutory phrase, no reasonable prospect of successfully prosecuting the proceeding. The answer isn't in a synonym, it's in the text itself.
So we have the new rule and we know the traps to avoid. But so what? What does this actually look like in the real world when you're making or defending one of these applications? Let's turn this legal theory into your practical toolkit. Okay, let's boil it down. Here's your Spencer cheat sheet. Yes, the bar is lower now. It's easier to get summary judgment than it was under the hopeless test. But, and this is a big but, it's not a free-for-all. Judges still have to be cautious. Your job isn't to prove the case is certain to fail. Your job is to persuade the court that its prospect of success isn't reasonable. And how do you do that? By avoiding those 3 traps and sticking like glue to the statutory text.
And this is the final question I want to leave you with. As an aspiring barrister, how does this change your case strategy? How do you advise a client on whether to bring one of these applications? And when you are in court, how do you frame your argument knowing the judge is laser-focused on that single question of reasonableness? That is the challenge and, frankly, the opportunity that Spencer leaves for every single one of us.